Good afternoon, ladies and gentlemen. Today is Wednesday, March 16th. It's 3:39. It's p.m. and we'd like to welcome you to the Business and Utility Subcommittee. Call this meeting to order. Madam Clerk, will you take the roll, please?
Representatives Alexander, Calfee, Hazelwood, Hodges, Holsclaw, Johnson, Manis, Thompson, Vaughn, Zachary, Chairman Boyd. Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Let it be noted that Representative Vital is in attendance. Members, before we get started, do we have any personal orders? If not, let's go ahead and get started. We are on our final calendar today, and item number 1, House Bill 2369, is rolled to the Hill. Next up is item number 2. That's House Bill 2645 by Representative Powell. Members, do we have a motion or a second? We have a motion. We have a second. Representative Powell, you are recognized.
Thank you, Mr. Chairman. I have an amendment on the bill, please.
What amendment code are you showing, Representative Powell?
014635.
That is what I'm showing too. Members, do we have a motion and a second on the amendment? We have a motion. We have a second. Members, or Representative Powell, you recognized on your amendment.
Sure. So the amendment makes the bill. If we could adopt the amendment, then I'm happy to explain the bill in full.
Members, let's go ahead and put that amendment on the bill. We're voting to put House Bill 014635 on House Bill 2645. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended and you are recognized on the bill.
Thank you, Mr. Chairman. This bill, as amended, deals with the regulation of decentralized autonomous organizations, otherwise known as DAOs. Essentially, a DAO is an organization represented by rules encoded as a transparent computer program and controlled by the organization's members. As the rules are embedded in the code, no managers are needed, thus removing the bureaucracy or hierarchy bodies. The key in understanding these organizations is in the word automated. There is an automated aspect to these organizations. For instance, you could have a bank account that is governed by all people in the LLC. Over certain triggers in the economy, the LLC may decide that is what happens in the economy, the LLC will invest in X. This is essentially how a DAO works. The reason it's so important is that there are already organizations being formed in the state around the country that are being transacted with this and making automated decisions, already hiring people, et cetera. So this, given this new concept, there's very little oversight to these organizations, and regulating and legally recognizing these organizations by the state incentivizes these groups to not only do business in the state, but to be answerable to reasonable constraints and regulations in any other business organization in the state. This would ensure that people that are hiring the business they are doing, the entities they're working with, are known and regulated. I believe in these technologies to be very cutting edge. We passed blockchain legislation back in 2018 that was one of the first blockchain bills passed in the state that also included information on smart contracts. We want to be a forward-thinking state when it comes to this, and this is very important, I believe, for the state to establish these DAOs. And if I could, Mr. Chairman, I actually have one gentleman who would like to provide testimony that's someone transacting business using one of these platforms. Actually, 2 folks, I'm sorry, if I could.
Absolutely, Representative Powell. So members, we are going out of session, and we're going to hear from Derek Brown and Jules Miller. If you guys want to come up here, and just be sure to make sure your microphone is on and state your name for the record, please. And just a reminder, you'll be limited to 3 minutes, and try to wind it up by the end, and we'll turn you off. Thanks.
Hello? Okay, it's on.
Hi, I'm Derek Brown. I'm the CEO of Bunches, a business based here in Tennessee.
I'm Jules Miller. I'm a partner at Mindset Ventures, a VC firm.
So I'd like to say that Tennessee, as you all well know, has long been a hub for providing companies like mine with a pro-business environment willing to foster innovation. It's one of the many reasons I moved my business here during the pandemic, and one of the many reasons I was excited to receive an investment from Launch Tennessee, a statewide program that you all helped authorize. As a state, we're also known for being willing to be on the front lines. We are, after all, the volunteer state. Decentralized organizations, also known as DAOs or DAOs, are another opportunity to do exactly that, be on the front lines of innovation. For some context here, the state code has already established the what of crypto, blockchain. It's already defined in the state code. The state has also already established the how of crypto and blockchain, smart contracts. It's already defined in the code. Both of these items already exist and were put there unanimously by both chambers here in the state of Tennessee. What's missing is the who of crypto, and that's exactly where DAOs or DAOs or decentralized organizations come in. While it's not entirely accurate, if it helps, it may be easier to think of DAOs as ELLCs, similar to how email is an electronic form of postal mail. These organizations have governance, balance sheets, and employees. As a business category, they are growing extraordinarily fast, with a market cap growing from hundreds of thousands of dollars to tens of billions in just a couple of years, solely in the US market. But they're all operating off the books in most states with no assistance or oversight from business-friendly governments like ours. How can these businesses engage in real estate transactions, hire personnel, or contribute to campaigns without legal recognition? The bill you're reviewing today in subcommittee allows for the creation and recognition of decentralized organizations in the state of Tennessee. This bill allows DAOs to engage in business here in the state while also positioning Tennessee as the hub for decentralized organizations and the capital, jobs, and innovation reputation that it brings here to the state. I'll also let my colleague, Jules Miller, speak on her business as a case study.
Hello, and thank you for having me. So I've been a venture capital investor for a while, also an entrepreneur with 2 venture-backed companies. I moved to Tennessee when I got pregnant to be closer to my family, and have been very, very impressed with the entrepreneurial community here, but we could do better. I was previously to my current fund, I was at IBM. I was running their blockchain ventures fund. So I've been professionally working in the Web3 space for many, many years, personally investing for many years before that. And I'm in the process of launching an investment DAO with over 100 professional venture capital investors. We've been in the weeds of legal and figuring out what jurisdiction to have our DAO in, and we decided to go offshore, honestly, because there weren't a lot of good options here, and we were very concerned about liability for the DAO members. And so the DAO world is not going away. I wanted to share some stats. It's still pretty early, but there's over $9.5 billion in DAO treasuries and over 5,000 DAOs. There are over 1.3 million members of DAOs around the world, so individuals who are participating in the DAO ecosystem, and there's over 50x growth in entity formation. And so most of those DAOs are not being formed in the US, and I think that's a real shame. So if you look at the regulatory environment, the best thing you can do for investors and entrepreneurs is to have clarity in the regulations. I think we are comfortable operating in a little bit of uncertainty, but not knowing if we have liability for something that's brand new and we're doing our best, but we don't have real clarity is super important. And I think that that is where this bill comes in. I think the limited liability for DAOs is the absolutely critical #1 thing that you can do to make more DAOs domicile in the US. In addition, even though the vision of DAOs is to be fully decentralized and fully automated, that is absolutely not the case right now. So almost all DAOs start with some degree of centralization and then move progressively toward decentralization. I think that there is not one DAO that I'm aware of that has gone to the process of being fully decentralized or automated, but they're getting there. This is why the manager-managed piece of the legislation is really important, because I think that there's a major gap in the Wyoming legislation. When you have professional managers who are managing DAOs, you can be more effective and efficient setting them up, and you can also decentralize much faster because you have people who know what they're doing, who are like fully working on this, rather than a lot of DAOs are people, it's not their full job, right? It's members who are maybe participating but not necessarily focused on it. So I think that's a really important piece of the legislation overall. So I think there's an opportunity here to be an early leader, and I think that this is a place that people want to move and live and start companies and make investments in, and I think if Tennessee can be an early leader in DAOs, there's like unlimited opportunity, and we're just at the very beginning of it. So thank you.
Derek and Jules, we appreciate you coming to speak today. Members, we've got a couple of folks here that are experts on this. Do we have any questions for them? Chairman Zachary, you're recognized.
Thank you, Mr. Chairman. Just one question. How many states have legislation like this on the books today?
Derek, you're recognized.
There's only one, and that's the state of Wyoming.
Chairman Zachary.
Thank you. And I know obviously we're in the beginning stages of this, but do you know how many states currently are evaluating pieces of legislation like this?
well, present company excluded, there's also the state of Florida, the state of Texas, and I'm sure additional states with a significant tech presence, being New York and California, may be in early stages of evaluating.
Chairman
Thank you,
Zachary.
Mr. Chairman. Thank you.
Members of the committee, do we have any other questions or comments? If not, Derek and Jules, thank you so much for coming out. It's great hearing from you today. Members, we're going back into session.
Thank you.
And Representative Powell, we are back on your bill as amended. Do you have any further explanation? Members, do we have any questions for Representative Powell on his bill as amended? If not, members, we are voting to send House Bill 2645 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you, Chairman and members.
Members, next up is item number 3 by Representative Harris. I do not see Representative Harris. We will roll him 3 bill spaces. Next up is item number 4, House Bill 2811 by Representative Hardaway. I do not see Representative Hardaway, so we will roll him 3 spaces as well. And next up is item number 5, House Bill 1987 by our own Chairman Vaughn.
Motion.
We have a motion. We have a second. Chairman Vaughn, you are recognized on your bill.
Thank you, Mr. Chairman, and if I could back up, I encountered Representative Hardaway on the way back into the chamber today, and he requested that his bill be taken off notice due to it being general subbed in the Senate.
Thank you, Mr. Chairman. And, Mr. Chairman, I do show that you have an amendment. What drafting code are you showing on
Yes,
that?
sir, 015186.
Motion.
That is the drafting code I'm showing. We have a motion. We have a second. Chairman Vaughn, you're recognized on the amendment.
All righty, thank you, Mr. Chairman, and that amendment writes the bill, but I would hope that I'll talk now, and then we can do whatever you see fit. I'm actually kind of embarrassed that I'm having to bring this bill to the state legislature. It's due to a lack of transparency that's inherent with the utility provider and monopoly that serves Shelby County. They are reluctant to provide the estimates whenever you receive a fee quote from them for either the extension into a new development or perhaps what they give to municipalities. Rare do they give you a breakdown of what it is that they're charging you for. We heard through our hearings that TVA does not allow discrimination between ratepayers. We have and they were somewhat hesitant when I asked that about capital contributions from individuals for system expansion, but yet there's no transparency in the process that we experience in dealing with one of the nation's largest utilities in our area. It's one of the nation's largest, if not the largest, provider of multi-utilities in the nation. As a result of that, we have brought forward here for consideration, and I appreciate the utility folks working with me on this, and that is we are simply requiring that whenever a quote for services is given to a municipality or to an individual or to an organization, that they show their work, that they show where that number came up from. We grant these folks a monopoly to operate in their in this state, and so we're requesting that they show their work. And I understand that it's complicated whenever you're designing utility systems, and so what we did was we said 14 days after an accepted and approved design, that's when they are required to give you your fee quote, and they have to show their work. And that's where this bill originates from. I think it's a little bit silly that we have to bring that to this body, but we do believe that transparency is important, especially when dealing with these monopolies. And so with that, sir, I'll answer any questions you may have.
Thank you, Mr. Chairman, for that, for explanation of the amendment. Members, we are on the amendment. Do we have any questions? Representative Thompson, you're recognized.
Thank you, Mr. Chairman. Chairman Vaughn, do you has Memphis Light Gas and Water given you a reason why they're not providing the information you've requested?
Chairman Vaughn.
Representative Thompson, usually it is, here's your price, and there is your price. When speaking with management of MLG&W, they have said, well, I can't believe we do that. And so this will provide more impetus for them to come around to where they can shine a little bit of transparency in their organization.
Representative Thompson, go ahead.
Has MLG&W, are they aware of this bill and this amendment? And have they responded to you about it?
Chairman Vaughn.
Yes, they are aware of it. Representative Thompson.
And they've not responded to
Chairman Vaughn.
you?
I'm going to say this as nicely as possible, Representative Thompson. They have a great representation team here on the Hill, but in general, they're not very responsive.
Representative Thompson.
Their representation here on the Hill, fabulous in working with us, representing their interests. When it comes to operations within the organization, not exactly forthcoming.
Okay.
Representative Thompson.
Speaking as one of the two people on this committee who received their services, I have not heard anything either. That's why I was just wondering if you'd gotten any feedback yourself.
Chairman Vaughn.
No, sir, I have not, but I can say this with all certainty, Representative Thompson. This is a good bill for it was brought due to my issues with Shelby County, but I'm sure there's other places. What in the world could be wrong with requiring utilities to show how they generate their fee basis whenever we heard from their de facto regulator, or let me say that, not de facto, I'll put regulator in quotes, TVA, that they do not allow discrimination within their ratepayers. How are we as individuals able to determine that unless there is some mechanism of a database of costs and being able to determine who's paying what? I understand that our costs in Shelby County may be different than Fayette County because they deal with Chickasaw Electric. But there should be no reason why a resident of Collierville should pay a different fee than a resident in Cordova or a resident in Arlington or a resident in Millington or a resident in Memphis. And that's what we're trying to get at, so where we will start building the base to where we can understand and shine a little light of transparency on the cost basis of what this organization's charging us and their customers and their ratepayers.
Representative Thompson.
Okay, thank you very much.
Members, any other questions for the chairman?
Question on the amendment.
Question's been called on the amendment. Without objection, members, we're voting to put amendment number 015186 on House Bill 1987. All in favor say aye. Aye. All opposed say no. The ayes have it. The amendment goes on the bill. Chairman Vaughn, you're recognized on your bill as amended if you have any further explanation.
I believe I've said enough, Mr. Chairman.
Question on the bill.
Question's being called. Without objection, members, we're voting to send House Bill 1987 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce. And back on item number 4, House Bill 2811 by Representative Hardaway is off notice. And item number 3 by Representative Harris. I saw him come in. Representative Harris. We need a motion and a second on Representative Harris. We have a motion. We have a second. Representative Harris, you're recognized on your bill.
Thank you so much, Mr. Chairman. I apologize. I was running another bill in another committee. And so I have an amendment on this bill, which is 015438.
That's what I'm showing. Members, do we have a motion and a second on the amendment? We have a motion. We have a second. Representative Harris, you are recognized on the amendment.
Thank you so much. So after taking into consideration some of what my colleague from Shelby County had brought up in last week, I have made some adjustments and changes to this legislation. And so what this piece of legislation now will do is change from 6 months to 30 days the amount of time that a landlord has to hold the remaining balance that is left over after they've paid any leftover attorney fees or rent, so that way they don't have to keep holding on to those funds on their books. And it also allows a landlord to donate to a charitable cause the property that is left behind if they choose not to sell or just dispose of the property. So everything else was removed from it, and I think I just received notice from Apartment Association of Tennessee that they are in good favor of this as well. Thank you.
Representative Harris, we appreciate you amending that, and I know the folks that have problems with it are very happy with that as well. I don't know if you're tracking the the Senate version of this bill, but it actually was gen subbed. So it's been common practice in the legislature, if the Senate version is dead, that normally you take it off a notice. So we don't make you do that, but I just wanted to throw that out there. I wasn't sure if you were tracking that version.
I did track that, and I did see that, but of course, the Senate is different from the House, and I think I wanted to allow the House to make a decision on it itself.
All right, members, we are on the amendment. Chairman Vaughn, you're recognized.
Thank you, Mr. Chairman, and to my colleague from Shelby County. I'm going to talk about one of the things I talked about earlier this morning with a fellow member from Shelby County is the results of this vote will either put a bill, it will either defeat this bill or this bill will be moved on to full commerce where we will again be hearing it without a Senate companion bill. While I tend to kind of like this bill, I still don't, as chairman of that committee and with the heavy lift we've got next week, I sure would appreciate it if we didn't have to vote on bills that weren't moving. And so I just want to offer that for your consideration before we take the vote.
Representative Harris, you're recognized.
So again, with taking to what my colleague from Shelby County has brought up again this week, I will go ahead and take this off notice and we'll bring this back next year. Great, thank you so much.
Thank you, Representative Harris. House Bill 2618 is off notice. Thank you, Mr. Chairman, for those very wise words down there. Next up is, I'm actually item number 6, so we're going to roll my bill to the Hill, and we will go ahead and move to item number 7. That's House Bill 1439 by Representative Wright. We have a motion. We have a second. Representative Wright, you are recognized on your bill.
Thank you, Mr. Chairman and committee, for accepting this motion. I'm going to be caught between competing or dueling amendments. So let me first say conceptually what this bill, what House Bill 1439 is doing. Tennessee Electric Ratepayers Protection Act. This is a consumer protection bill dealing with municipally owned utilities, and in this case, electricity, when the municipality wishes to terminate, sell the electric utility. What happens with the proceeds? And I need it to be looked at from about 5 different perspectives. What's the retirement plan of the utility that's being spun off? How does the utility value be determined, like through an arm's length committee or organization? What might the controller of the Treasury think? What might be the problem that is precipitating the utility being sold? A business feasibility plan might be a good terminology there. And about the 5th thing, should the consumers being protected have a right to a referendum? And then through all of this, what are the ways out through going to court? And then lastly, something that overrides everything we do, what's the transparency of what's taking place? How will meetings be conducted and things along that line? The reason that I'm carrying the bill is because conceptually, that's all I'm speaking to is a concept. The ratepayers need to be protected because if the utility is sold and millions of dollars recognized, then the consumer has been shortchanged because the utility should be being operated by the construct of we do what's necessary today to provide good service, and we maybe need to retain enough capital to execute a capital plan for the future, which makes it a good utility. With that, Mr. Chairman, there are two amendments, two separate amendments.
Thank you, Representative Wright, for that background on the issue. So back to the amendments. I understand that you had an amendment that you were coming with, but there's a committee amendment by Chairman Vaughn that I think you guys have agreed upon. So are we taking up, are you deferring on your amendment and we going with Chairman Vaughn's, or what's the?
I'm relying on the WISE capability.
Okay.
Thank you, permission.
Yeah,
granted
Chairman,
to
Representative.
use WISE.
Right. Okay.
of
So
the
Representative
chairman.
Wright, let me guide you on this a little bit. We're going to probably go with the committee amendment. I'm going to recognize Chairman Vaughn on that. Chairman Vaughn, what's your drafting code on that?
Thank you, Chairman. It's 015837.
That's what I'm showing too. Do we have a motion and a second on the amendment? We have a motion. We have a second. Chairman Vaughn, you're recognized on the amendment.
Thank you, Mr. Chairman, and I appreciate my colleague, Representative Wright, being nice about and very open and willing to listen with regards to this. I also appreciate my friends at the Tennessee Municipal Power Association for being very responsive and providing input on this. Let me give you all a little bit of background on why this is necessary, and particularly it's of interest to me moving forward. Again, we know that municipalities, sometimes I believe there's over 100 municipally owned electric systems, 60 in our state. Some of these municipally owned utilities are ran by different organizations, but in our neck of the woods, it's owned by the City of Memphis, and it is controlled by the Memphis City Council. They do have a board, but it is controlled by the Memphis City Council. That has been a very successful utility. They provide services to all 5 municipalities outside of the City of Memphis, plus unincorporated Shelby County. In addition, they 40% of their ratepayers are not Memphians, yet they are controlled by the City Council of the City of Memphis. So when you look at me and the area that I represent, I'm completely unrepresented in the board of this monopoly. Should they choose to sell it, which with all the struggles that they fought through admirably in the last month with their outage problems due to the ice storm, there was even press that the mayor said we should consider selling it in order to increase the reliability in the going to more underground lines. So with that being said, we really don't have in state law much that talks about the disposition of utilities by municipalities. Again, TVA is the regulator or customer service representative, whichever one that you want to choose. And when it comes to how they're going to wind up and retain a customer regardless. So what we have set about doing is setting about a mechanism of if someone wanted to sell more than a quarter of their system, how are the proceeds distributed? What mechanisms takes that into account? And what are the important things to the public with regards to that? We've worked on them. Representative Wright has an amendment. Mine differs from it slightly. And what I'd like to do is to bring light on this subject that there's a number of folks in the state who are represented by utilities and do not have representation or any matter of redress against the people who provide those services. So today, as it stands, if MLG&W can convince TVA that it's right for them to sell to another power provider, the residents of District 95, probably the finest district in the state of Tennessee, would, although they've paid into the system, they've depreciated the system, they've made capital contributions, they would receive nothing. And so Memphis is sitting on a tremendous asset that affects many other people. And so what we're trying to do is come up with a structure and an order of what our intentions are and how we address the needs of the citizens of Tennessee. Because I think we've heard in our testimony from TVA that TVA, again, they only regulate the people who they buy power from. I'm not sure that they are going to look out for the interest of the citizens of Tennessee and I don't want to cede this body's responsibility of regulating that utility interest. I think that while they do indeed have federal regulatory oversight, that does not preclude us as a state body from also putting our rules and requirements on them. And as we see these entities consider more out-of-the-box thinking, again, such as not renewing a power contract and buying power on the off market, those are things that I think, especially when you're looking at a utility that controls 10% of TVA's load factor, what does that do to other utility districts and other consumers within the state of Tennessee? So I don't see how those decisions can be made in a vacuum. This is the very first start at us trying to provide a different perspective on electric utility regulation within this state and making sure that all views of all ratepayers are considered whenever transactions that affect them are taken into account. Now then, I'm done preaching, but let me give you some sharp differences between the amendment that Representative Wright has and the amendment that I have said. In Representative Wright's amendment, it calls for a referendum of the ratepayers. No, referendum of the tax of the residents of the municipality of the ownership. I don't think that's. I think that's what elected people are for. I think that's the representatives have the right to determine that. If they want to have a referendum, which I think would be a very smart thing to do, I think it's up to them. But the reason I say that is because voters have the opportunity to redress the people that make bad decisions. If I'm making a bad decision that people don't like, I suspect my opponent will get a vote. And so that's my position on that issue. Another was what to do with the proceeds. After settling up the account with any retirement benefits, my bill considers the fact that the seller determines what to do with the proceeds. And so there's a little bit different perspective with regards to it. And the last major difference is that from a standpoint of providing a business plan to the comptroller, I don't have as aggressive a role in the comptroller because, again, back in the city of Memphis should be regarded, and when I speak of city, this is not a particular bill, this is a statewide application, it's just what I know and what I'm familiar with. They made a smart decision getting into the electrical power business back when it was early. And so moving forward, if they decide that they want to make a change in the way they do it, I think we should allow that to happen. I just want to make sure that ratepayers are protected and that they're not inhibited or precluded from being able to do that. And with that, Mr. Chairman, I'll answer any questions.
Mr. Chairman, we appreciate that very detailed explanation of the amendment. Members, do we have any questions for Chairman Vaughn on his amendment? If not, we are voting to send voting to put amendment number 015837 on the bill. All in favor say aye. Aye. All opposed say no. The ayes have it. The bill is amended. Representative Wright, you are recognized on your bill as amended. Do you have any further explanation of the amended bill?
Thank you, Mr. Chairman. This is a consumer protection bill.
Thank you.
And I thank the chairman and committee.
Members, do we have any questions for Representative Wright? If not, we are voting to send House Bill 1439 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you. Thank you, Mr. Chairman, committee. Yes, sir.
Members, next up is item number 8. That's House Bill 2283 by Representative Beck. Remember, we have a motion. We have a second. Representative Beck, you are recognized on your bill.
Thank you, Mr. Chairman and committee. This is my bill. We recently had a tragedy in Nashville.
Representative Beck, stand by just a minute. I believe Chairman Vaughn has an amendment he's putting on there.
He does.
Okay, Chairman Vaughn, what drafting code are you showing on that?
01353, Mr. Chairman.
That's what I'm showing as well. Let's go ahead and get that. That makes the bill, doesn't it, Chairman Vaughn?
Yes, sir,
Okay.
it does.
Okay, let's go ahead and vote on that. Members, we are voting to put amendment number, we need a motion and a second on the amendment. We have a motion, we have a second. We are voting to put amendment number 013453 on House Bill 2283. All in favor say aye. Aye. All opposed say no. The ayes have it. Representative Beck, you were recognized on your bill as amended.
Thank you, Mr. Chairman and committee, and thank you very much to Chairman Vaughn. First of all, I want to apologize for this being a little bit tardy to the chairman and the committee. I've been working diligently with the Commerce and Insurance, ABC, and the stakeholders, to make sure I got this right. Last August, security cameras showed a group of men holding down a 22-year-old Dallas Jordan Barrett during an altercation at Whiskey Row on Broadway. He became unresponsive and later died. Since then, criminal charges have come against 6 men who were involved, 6 employees that were involved in the altercation. 4 were unlicensed security guards, and 2 were licensed even though they had no training. Under current law, security guards can operate for a location under a proprietary security organization, a PSO, that is licensed through the Department of Commerce and Insurance. These PSOs do not have to have any education or training when they come under the organization, whereas if you work for an agency and you're a security guard, you have to have several hours of training and you have to go through a background check. What we're trying to do here is close the loophole for the PSOs between the untrained bodyguard, or not bodyguard, excuse me, the untrained guard and the ones that work for an agency. So, and we also are asking in the training that they be certified in CPR, and they also have some de-escalation techniques, proper safety and restraint techniques in their training. And so that's what we have today. This was a tragedy in our city. This will only apply to PSOs where alcohol or beer are sold. So it does not apply to any other organizations, just where you have an alcohol license or you have a license to sell beer. And with that, Mr. Chairman, I'll be happy to take questions.
Thank you, Representative Beck, for that explanation. Members, do we have any questions for the sponsor of the bill? If not, we are voting to send House Bill 2283 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you, Mr. Chairman, and thank you, committee.
Next up, guys, we are back up to item number 1, and that's House Bill 2369 by Chairman Powers.
Motion.
We have a motion. We have a second. Chairman Powers, you are recognized on your bill.
Thank you, Mr. Chairman, committee.
And Chairman Powers, I show some amendments here. Which one of these are you going to use?
We've actually got one amendment, and that is amendment number 014864.
That's what I'm showing.
Motion on the amendment.
We have a motion. We have a second on the amendment. Chairman Powers, you recognized on the amendment.
Okay. First of all, the amendment just simply gives Tennessee Public Utility Commission the right to fine someone out of compliance, and it also moves the Court of Appeals, if there is a final appeal, to the Middle Tennessee Court of Appeals.
All right. Members, you've heard the explanation of the amendment. Do we have any questions for the sponsor on the amendment? If not, we're voting to put amendment 014864 on House Bill 2369. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, we are back on your bill as amended.
All right. Thank you. House Bill 2369 will designate social media platforms as common carriers. House Bill 2369 comes to us from a growing number of concerns and outrage from our constituents around our state who have been censored, blocked, and banned by big tech, a primary venue for free speech and sharing of ideas or social media. The structure of this bill is built on an opinion of Justice Clarence Thomas wrote in the Biden versus Knight case, and he said, if part of the problem is private, concentrated control over online content and platforms available to the public, then part of the solution may be found in doctrines that limit the right of a private company to exclude. In many ways, digital platforms that hold themselves out to the public resemble traditional common carriers. So you may have been told some misinformation about this bill, and I just want to clarify, this is no growth in government, and it's protecting the free speech of everyone, all Tennesseans, that they may have. That all we're asking for is that you do not ban political speech and political viewpoints. And I'll give you an example. I did want to weigh in on just a couple of things that we had done. Well, I missed the... Anyway, I know Facebook and other carriers like that, they do a great job of banning a lot of different things on here, and they have the right under Rule 230 to ban anything offensive, and so I want to give them credit for doing that, but that does not give them the right to ban political speech and political viewpoints that are not offensive. So with that, we just believe that it's constitutional under U.S. Code Title 47, Chapter 5, Subchapter 2, Section 230. And I'll give you examples of some people just that I know that have been banned. My cousin was banned for 2 months just because he made a political viewpoint about the current administration. Another Knox County Republican Party was banned for 2 months because they made it. And as we know, former President Trump has been banned, and yet the Ayatollah Khomeini in Iran, who said death to America, has not been banned. Therefore, the legislation that before you simply tries to accommodate these by asking the Tennessee Code annotated Title 4, Title 47, and Title 65 relative to social media, and would bring these companies under the common carrier law so that Tennesseans and the public at large are not discriminated against. And with that, Mr. Chairman, I renew my motion.
Thank you, Chairman Powers, for that detailed explanation. Members, you've heard the explanation. Do we have any questions? And we have a list here. Chairman Zachary, you were recognized.
Thank you, Mr. Chairman. And sponsor, thank you for bringing the bill. I actually was working with Speaker Sexton on a bill very similar to this with very similar language. I appreciate you bringing it in the heavy lifts. That way I don't have to do it, so thank you. Just a couple of things. I think it is important to remember so much of the conversation related to this is centered around the Communication Decency Act of 1996 and Section 230. So many times, and I think we even had somebody testify, we have conversations here about government overstepping its bounds. And sometimes the conversation is made about this argument. But it's important to remember that when government interjects itself, then we are part of the process, so then we have a responsibility to course correct, especially on the state level when the federal government continues to fail, as they do over and over again. It's important to remember we have this bill in front of us because Congress on both sides of the aisle have refused to address Rule 230. And Mr. Chairman and Committee, it's important to know that in 1996 when this passed, Rule 230, which I'll spare you, which I've got right here, I'll spare you reading Rule 230 because it can be lengthy. There are Supreme Court there are questions related to precedent in the Supreme Court about how constitutional Rule 230 is. And so everything that we're talking about is based on Rule 230. And so with that being the case, the only thing the carriers can do is look at this as common carrier law. And to regulate big tech companies is common carriers. Because if we think of Verizon, we think of AT&T, we think of Lumen, whoever it may be, it would be absurd if we sat here and talked about regulating the information flow that goes on with carriers. Right. And so that's simply what we're saying here, is that this is, when you regulate these guys as a common carrier, which the state has the ability to do, There is no Supreme Court precedent related to regulating tech companies as a common carrier. So with putting them as a common carrier, we're simply saying the information flow goes back and forth. Right. Because to your point, when you talk about censoring, suppressing, and deplatforming, that's exactly what we're talking about. And some local examples to give you. I presented a bill last year where YouTube took the video down. I presented in committee, they took the video down, and all I did was quote Ronald Reagan and quote the Constitution. Wow. There was not much opinion or conjecture, and they took that down. Mayor Jacobs, who is our mayor in Knox County, put a statistic in a study related to masks, and Twitter did the same thing to him. Alex Berenson, who was a New York Times journalist, has been banned. A sitting congressman has been banned from YouTube. Dr. Robert Malone, who is the inventor of the mRNA vaccine, he has been banned from Twitter for providing expert opinion. And so the list goes on and on, so I'll stop there, but those are the most recent examples. And if the states don't get control of this issue, the federal government's not going to do anything. And again, both sides, they've proved their inability to tackle tough issues. We as the states must protect the First Amendment rights of Tennesseans. It becomes a First Amendment right because of what Congress did in 1996 with Rule 230. So it absolutely does, because government stepped in to regulate. Now the states have to take a step to protect the freedom of speech and the voices of Tennesseans. So I just said all that, really not a question, more comments, Mr. Chairman, but I appreciate you bringing the bill. It's needed. This has already passed 7-1 in the Senate committee, so I appreciate their efforts, and I'll be supporting the bill. Thank you for carrying it and bringing it.
Thank you. Could I make
Chairman
just
Powers,
one
yeah, go ahead.
comment? I mentioned Section 230, and I'll read that. United States Code Title 47, Telecommunications, Chapter 5, Wire or Radio Communications, Subchapter 2, Common Carrier, Section 230, the protection for private blocking and screening of offensive material. Nothing about political speech, but offensive material, and we're not trying to change that.
Thank you, Chairman Powers. Next up, we have Representative Thompson. You are recognized, sir.
Thank you, Mr. Chairman. So I think the main villain in all this is Facebook. Is that right?
Chairman Powers.
Yes. No, not really. It would be any political social media, any social media. So it would include Twitter, it'd include Google, it'd include whoever has a social media platform.
Representative Thompson.
What would you refer to? What would be examples of offensive behavior, in your opinion?
Chairman Powers.
Well, let me just read you, and this is a good example of what we were talking about a moment ago. Here's some things that Facebook does ban, and they do a great job of doing this. This is only last quarter of last year. 4 million pieces of drug content, 1.2 billion pieces of spam content, 905,000 pieces of content related to terrorism, and these are all increases over the previous quarter. So they do a great job of doing that. But the one thing that they shouldn't be banning on here is political speech and political viewpoints. And that should be a bipartisan. This should be a bipartisan bill because none of us want that banned.
Representative Thompson.
I agree. I've seen a lot of offensive speech, left and right, on Facebook. I don't live there, but I try to look at it once or twice a day, maybe, or a week. But the speech I'm thinking about, we have, and I've seen falsehoods too. I see people putting false information out. I just skip over it and forget about it. But would a regular behavior of false information of a offensive nature to a lot of people, would that be considered a reason to, or is that protected? They can a common carrier not ban somebody from their site? Should they continually put false information that's either offensive or potentially harmful to other people?
Chairman Powers, go ahead.
Well, they have a lot of flexibility under Rule 230 about offensive material, but I'll give you an example of misinformation. We've heard if a year ago I had got on and on any social media platform and said that the vaccine doesn't work, that it doesn't prevent someone from getting COVID. I had both shots. I had and a booster. I still got COVID. So yeah, it probably was a therapeutic, but it didn't prevent COVID. But if I had said that 1 year ago, I would have got banned from many social media platforms. Same thing with the mask. If you said masks don't work, now the CDC has come out and said, no, they don't work. So their definition of misinformation could be anything. And so it's about offensive material. That's what Rule 230 is about. And their misinformation is just their interpretation of it. So they're actually preventing free speech when they do that.
Representative Thompson, you have anything else?
Just a little bit. I'm not sure you answered my question. Can you ban some? I mean, would be allowed to ban somebody if they continually throw out offensive and untrue, clearly false information?
Chairman Powers.
Yeah, not under Rule Section 230. You know, they have that rule where they can do offensive language and all the things that we covered a minute ago. But if somebody's putting out information or a political viewpoint, you know, some doctors have come out and said that the vaccine didn't work. Other doctors said that they did. But that was just really their opinion. So there was never been any type of scientific fact. And we know now that it doesn't work in every case. So misinformation is just an opinion like you and I might have, and no, those shouldn't be banned because it's only an opinion, not a statement of fact.
Representative Thompson?
Yes, I'm not very comfortable with this. I think that we have a trend right of government getting involved in private businesses, and this just seems to be another one. I see a lot of your points, but I'm probably not going to support it for that reason.
Okay.
Chairman Powers, go ahead.
Yeah, and I understand that completely. And if the federal government, going back to what Representative Zachary said a moment ago, if the federal government was doing this, if they would pass a law that would prevent this, we wouldn't have to do it at the state level. And other states have tried it. Nobody's ever tried it as a common carrier law. And so that's why we're doing it. And that's why when we had the opinion a while ago of the Supreme Court that this was the only way to do it was to treat them as a common carrier. That's why we're pursuing that route.
Representative Thompson, do you have anything else? Okay. Next up, we have Representative Calfee.
Thank you, Mr. Chairman. Mr. Sponsor, this morning, I hadn't really heard much about this till this morning, and about a half a dozen people were talking in my ear about a half a dozen things, and I was getting nauseous because I'd heard all I wanted to hear about Airbnb. But I thought somebody told me that if this bill passes, an existing state agency would regulate what's put on social media. Did I misunderstand, or is that true?
Chairman Powers.
Yeah, that's incorrect. Yeah, we have an agency that can take it over through the Public Utility Commission. They can do it, but they would not be regulating free speech at all. All they would be doing is somebody filed a complaint for what we were talking about a minute ago. If they had been shadow banned or deplatformed, then it would go back as a complaint through the Public Utility Commission. Has nothing to do with them banning free speech. This is about protecting our free speech.
Representative Calfee?
Yes, thanks for clearing that up. And I'll soon be 73 years old, and I've never tweeted, I've never looked at Facebook, and I don't intend to. My wife says I have a legislative Facebook, but I've never seen it. So thank you.
Chairman Powers.
My wife said I had a face for radio, so I understand completely. Go ahead.
Next up, Chairman Zachary.
Thank you, Mr. Chairman. Just in some of the previous comments, one of the reasons for banning or suppressing or censoring has been misinformation. I think it's important to read the language of Rule 230 and how Rule 230 has been distorted by the tech companies. The actions that can be restricted are, as quoted in Rule 230, obscene, lewd, filthy, excessively violent, harassing, or objectionable. Misinformation is not part of that. The bottom line is, as adults, or whomever, when you get on, you have to use a certain amount of discretion if a politician from the left or the right or a doctor, whomever it may be, puts information out on Twitter or Facebook or whatever. But it is important to remember, Clarence Thomas has referenced this in his opining on this as well, that we have allowed, I say we, Congress has allowed the tech companies to run wild on this when the only things are mentioned are obscene, lewd, filthy, excessively violent, harassing, or otherwise objectionable. Right. They have taken great leeway, and Congress has done nothing to bring them back in based on a law that they passed in 1996. Right. And so I think it's important to remember that misinformation's got nothing to do with this. We, the people, have allowed Congress to allow this to reach this point, and that's part of the problem. So all we can do is handle this on the state level. Both Texas and Florida have passed legislation related to this. But it has been recommended by most think tanks that the only way to really address it is common carrier because some of the challenges Texas and Florida have faced with that. So again, thank you for bringing this, and it's important to make sure that we're looking at the facts and the proper wording of Rule 230 as we talk about what the federal government has done interjecting themselves into this. Thank you, Mr. Chairman.
Chairman Powers.
Yeah, and I agree completely with what you said. And the thing about it is, if you look at the Facebook website, let me just quote something. We want updated internet regulations to set clear guidelines for addressing today's toughest challenges. They also said, should regulation define harmful content should be prohibited from the internet, but they've addressed Congress and asked them for the regulation, because another thing that they said was, I don't know if it's right to have a private corporation like Facebook dictate what those boundaries are. Now, this is a Facebook video commercial. One other commercial, regulation can help us better define what is acceptable and what is not. These are straight from Facebook video commercials. So, with that.
Thank you, Chairman Powers. Chair Lady Hazelwood, you recognized.
Thank you, Mr. Chairman. Just a couple of questions about, I think I understand the theory, but how this would work in practice. Mm-hmm. So if there is what I feel is objectionable material, then I would have the ability to file a complaint through the Public Service Commission. That commission would investigate who would decide if my complaint was valid or invalid, and how would that be done?
Okay,
Chairman Powers.
I'm sorry. It's actually Public Utility Commissions who actually go. The old Public Service Commission that we used to have at one time. But yeah, it would be filed through them and through their Consumer Advocate Department. And I have the Public Utility Commission here if we want to go out of session for a minute. I don't know if it would be allowed or not, but he is here with us, and I've worked with him on this language to go back, and it goes back to the amendment that we filed a while ago to where they could go back and actually find someone. And it's all about, it's not the objectionable language that we're looking at, it's deplatforming someone, shadow banning them, which is moving them down the list of when you Google someone or whatever, and you're putting them down at the bottom of the list or on a bad page or whatever. But those are the two things that we're talking about, deplatforming and shadow banning or banning someone. But the objectionable language that they're looking at on here, it would still fall under Rule 230. It would still be that offensive language that we were talking about a while ago. But those were the only things that should be banned or should be blocked by Facebook or Twitter or other social media platforms.
Chair Lady Hazelwood, you recognize?
I'm sorry, I misspoke. My concern was the banning and who would determine. Right. I'm just, it seems we're ceding a lot of control and authority to the Public Service Commission or whomever to determine in their viewpoint if this took place. My follow-up question, because these are very significant fines that we're talking about, so would those fines be put into place from the date of the filing, from the date of if it was determined that somebody was banned or shadow banned, or they were moved down, whatever the case may be? Would it be from the date that happened? How would those fines be? Because those are some large numbers. Yes. So how would those be calculated?
Chairman Powers.
Yes, on the amendment that was filed, and it talks about after 60 days of providing the operator remains out of compliance, then that's when the commission will conduct a hearing, and then that's when from that point on. But the commission would determine at that point if somebody had been banned or shadow banned from a platform, and the fines would not start until after they had a proper hearing.
So there would be no backdating of the fines.
Sure.
Again, I very much appreciate what you're trying to do, because I don't think anybody would deny that it's an issue. I just have concerns about the process, and it's just something I think we really need to be very careful and judicious about as we set up. Anytime that you give that sort of authority to any group, I think we need to be very cautious about it. But thank you, Mr. Chairman.
All right.
Chairman Powers.
Thank you, and I agree, and we've done everything, and we're trying to bring in all the stakeholders to make sure that we don't have any unintended consequences too, that we might be possibly affecting some company that really has nothing to do with its social media platform. So we're working on that too.
Chairman Powers, I have a sort of a technical question. Last time we discussed this, you had mentioned the Attorney General's office you were considering using, and I noticed you moved it back to TPUC. But you did say the Consumer Advocate Division, which had a bill up in your committee the other day on that. So it actually would go through TPUC, but ultimately they would be using their resource over in the Attorney General's office for the investigation. Is that correct?
Yes.
Chairman Powers?
Yeah, yes, and actually we have talked with both, and we're looking at this and see if there's any available vacancies open that we might be able to do it through TPUC and maybe not have any kind of physical note to it. And it looks like we might be able to do that. If not, we have talked to the Attorney General's office, and they will be glad to handle it. We're in negotiation with both of them right now.
Thank you, Chairman.
Either one of them would take the note off the bill.
Thank you, Chairman Powers. Members, do we have any other question for Chairman Powers? If not, members, we are voting to send House Bill 2369 as amended to full commerce. All in favor say aye. Aye. All opposed say no. No. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you, Mr. Chairman. Thank you, committee.
And I'm going to be handing the gavel off to Chairman Vaughn for item number 6, House Bill 2288 by myself.
Good afternoon, everyone. Come on, let's turn those frowns upside down. We're about to get to the fun part of the process. We're about to hear House Bill 2288 by Chairman Boyd. Do we hear a motion on it?
Motion.
Second.
Sorry.
Thank you, members. I appreciate that.
And House Bill 2280 has got an amendment there. I see Chairman Boyd is. Could you
Chairman Vaughn,
that drafting code at me?
Yes, sir. I'm showing 015330.
That is it. All right, so you're in proper posture. Bring it on.
Thank you, Chairman Vaughn. So, members, as many of you know, if you've ever been involved in a timeshare before, their tactics sometimes can be rather strong-armed and can go on for hours. And oftentimes people will sign on to get out of the meeting, and then later they have some reservations about having bought it, and there is a 10-day time period by which they can get out of one of those contracts, but you actually have to hand deliver or mail their notice, which is cumbersome, and sometimes stuff gets lost in the mail and people can be avoided. So what this bill does, it's very simple. It adds language to the statute that gives the consumer a third option, and that is to do it, I'll read it to you, by electronic means, as long as the means include a digital timestamp. So, Mr. Chairman, I'll take any questions on the amendment.
All righty, thank you, sir. Do I have any questions for Chairman Boyd?
Question on the amendment.
Oh, we got a question on the amendment. All those in favor, please signify by saying aye. Aye. Any opposed, no. That amendment is on there. Questions on the bill. Do we have any questions on the bill?
Question on the bill.
The question has been called. All in favor, please signify by saying aye. Aye. Any opposed, no. Ayes have it. You are off to where you're going. Full commerce. Be off.
Members, that concludes our regular calendar for the day, so we're now taking up our special calendar. We've got a little bit of housekeeping on it. Item number 1, House Bill 2100 is referred back to the clerk's desk. Item number 2, House Bill 1757 is referred back to the clerk's desk. And item number 4, that's House Bill 28, is referred back to the clerk's desk. Next up is item number 3. That's House Bill 645 by Chairman Faison. Do we have a motion and a second? Second. We have a motion. We have a second. Chairman Faison, you are recognized on your bill.
Good afternoon, committee. Mr. Chairman, very good to be with you, and appreciate the full chairman getting everybody livened up.
And Chairman Faison,
with me.
I show a couple of amendments here.
Yes, sir. We do have a couple of amendments.
Okay. What drafting code are you showing?
The first one that I would show is drafting code 15360.
That's what I'm showing. Do we have a motion and a second on that amendment? Motion on the second. We have a motion. We have a second. Chairman Faison, you are recognized on that amendment.
Thank you. And committee, this amendment writes the bill, and with y'all's indulgence, can we just adopt? And then I know there's some people who really love this bill and want to testify against it since they love it so much. Maybe go into recess and let them do that. Or is that to the will of the
Chairman,
committee?
that is what we will do. Members, we are voting to put House Amendment 015360 on the bill. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is amended.
And then I have one more amendment. It's just a technical correction, drafting code 5777.
Can you read that drafting code one more time, Chairman?
5777.
Chairman, I've got a 15777.
Yes, sir.
Okay. Do we have a motion and a second on that amendment? We have a motion. We have a second. Members, we are voting to put Amendment 015777 on the bill. All in favor say aye. Aye. All opposed say no. The ayes have it. The amendment's on the bill. Stand by just a minute, Chairman Faith. And members, we have one more amendment coming from a member of the committee, and that's Chairman Zachary. Chairman Zachary, you're recognized on the amendment.
Thank you, Mr. Chairman. I have drafting code 15901.
That's what I'm showing. Do we have a motion and a second on the amendment?
Motion. Second.
We have a motion. We have a second. Chairman Zachary, you are recognized on your amendment.
Thank you, Mr. Chairman. Members, this is a friendly amendment. Chairman Faison has worked with me on this, and this just simply excludes communities who do not have law enforcement. I'll be glad to answer any questions.
Members, do we have any questions for Chairman Zachary on his amendment? Representative Thompson, you recognized.
By communities with no law enforcement, in other words, do you mean communities or municipalities with no police force of their own?
Chairman Zachary.
Thank you, Mr. Chairman. Yeah, under code 137602.3, it's anyone who does not have at least one part-time or full-time law enforcement officer. Yes.
Representative Thompson. Okay. Members, do we have any other questions for Chairman Zachary? If not, members, we're voting to put Amendment 015901 on House Bill 645. All in favor say aye.
Aye.
All opposed say no. The ayes have it. The amendment goes on the bill. Chairman Faison, you are recognized on your bill as amended.
Thank you, Mr. Chair.
Would you like to have some people testify?
Yes, sir.
Okay. Members, we are going out of session. And first up, we have Mr. Tom Lee. Tom, if you'll just make sure your microphone is on and state your name for the record. And we're limited to 3 minutes, sir.
Thank you, Mr. Chairman. Members, pleasure to be with you today. My name's Tom Lee, and I'm here on behalf of the city of Nashville. Pleased to talk to you today about House Bill 645, and I'd like to sort of start by addressing, I think, a principal issue for many of you, because last night in the Senate hearing on this bill, an issue was raised as to whether the city of Nashville's council, legislative body, has legislation pending presently in front of it that would in some way ban, effectively prohibit owner-occupied short-term rentals. Some of you have asked that question. The answer to that question is no. The answer to that question is no. There is no pending legislation that would do that. There is pending legislation which has been sitting in the council for 2 years. We know this because it's called BL 2020-504 that would create the owner-occupied short-term rental overlay district so that people who want to operate an owner-operated short-term rental could do so in districts of the city where the zoning code would otherwise prohibit it. The only legislation pending before the Metropolitan Council right now, that overlay bill, would expand the availability of short-term rentals by the expansion of these districts. Having said that, that bill has been parked for 2 years and has not moved. There is no legislation banning owner-occupied short-term rentals before the Metropolitan Council. In fact, Nashville is open for business, for short-term rentals, and for owner-occupied. We have 6,140 permits right now. 4,630 of those units are owner-occupied. That's the most in the state, and it's not close. It's good for our guests. We have a lot of places for them to come, and as you know, we like to have guests in Nashville. It's good for our property owners. 88% of all applicants for permits get them received timely. 88%. That's over the period of time since 2015. That's good for our property owners, and they are profitable. AirDNA says this is the fourth most profitable Airbnb market in the country. Finally, good for our communities. Our compliance rate with our regulations is over 90%. Very few communities hit that. So we want policies that are good for our guests, good for our property owners, and good for our communities. We think we've achieved those. There are things in this bill that are addressed at a narrow band of communities, and I think some folks have heard that they are addressed only at the city of Nashville. They are not. They are not. Other communities that have read this amendment since it became available a couple of days ago have come to realize that they too are covered. We know now of the city of Chattanooga. We know now of the city of Gatlinburg. We know now of the city of Pigeon Forge, all of whose law directors have come forward to say, we believe we are covered by the provisions in the bill that appear to apply only to Nashville. Please don't take my word for that. Please contact those cities, and I think many of you have, and you know. Most of the bill, in fact, is not about Nashville. In the provisions of the bill that apply statewide, and thank you, Mr. Chairman, I'll wrap up very briefly. You will find it more difficult to punish bad actors. You'll have to be able to find them guilty of 3 strikes, not just ever, but within 1 year, which means not just administrative hearings, but court processes. Why will people want to go to court? And this is the last thing I'll say, thank you, Mr. Chairman, is this. This bill allows for persons who feel aggrieved by the actions of local government to go to court and get punitive damages. This provision of the bill, it appears to be parked inside the narrow portion of the bill, but it applies to all appeals. This would become the first time, and maybe you think it's a good idea, but it would be the first time that anyone could obtain punitive damages against a local government.
Tom, I hate to cut you off. We're out of time. Sorry.
And I appreciate the time of the chair, and I appreciate the time of the committee. Thank you very much.
Tom, if you'll stand by, we may have some questions for you. So,
I'm happy to answer
members,
questions.
Since while we're out of session, do we have any questions for Mr. Lee? If not, Tom, thank you so much for coming. Appreciate your time.
Thank you, Chairman.
All right, members, we are going back in session, and we are back on House Bill 0645 as amended. Chairman Faison, you are recognized.
Thank you, Mr. Chair and committee. I want to just kind of give us a brief history lesson. One of the things that is so special about our country that was kind of from the inception is that we have an expectation as United States citizens of the behavior of our government. If you look at other countries, there's no expectation. You might be guilty today, you might not be guilty tomorrow. They can just come in and do what they want often. But as Americans, we have, for 200 plus years, enjoyed the privileges of having expectation. The second thing I think historically that we look at is property rights. If you study our Constitution, which all of us swore an oath to, there is actually more to say about property rights, individual property rights, than there are about gun rights. There are about First Amendment rights. It's something that our founding fathers thought were incredibly important. What House Bill 645 seeks to do is to allow these residents in Nashville to have some expectation. So I'll take you back to 2015. Some of us were still elected back then. Airbnbs and short-term rentals really came on the line, and they started spreading out throughout the country. If you would remember, Nashville started giving out permits left and right. Anybody who wanted a permit to do a short-term rental, you were able to get it. Obviously, they saw there's some situations here, there's some partying going on, so they started just making all types of regulations. Fast forward from 2015 to 2018, then Chairman Sexton, now Speaker Sexton, realized that we've gone too far in overcorrecting, which we do in legislative bodies. We go too far. We set out to see what we could do to preserve some property rights and make sure that the government hasn't gone so far that they've just squashed property rights. Since that time, we've passed a few bills about collecting taxes, making sure that's right. There's always been a fight with it. But since we passed that in 2018, there has been fudging on those laws. There's been manipulation on those laws. One of the things that this bill does is make it, if you have a permit and you and your wife or your partner, whoever you're with, go through a divorce, you split up, you lose your permit to have an Airbnb. Also want to let you know that this is only for the people who live in their dwelling. This isn't for somebody to be able to come outside, buy a bunch of houses, buy a bunch of condos, and rent them out. This is for the people who actually live and sleep, according to our TCO, where their address is, where their voter registration is, right then and there. So we're talking about people who are wanting to be able to rent out their mother-in-law or rent out the basement. We're not talking about people wanting next door, right here. So where they sleep, this is going to take care of them. People say, well, how does this only impact Nashville? If you look at Section 8, on page 3, Section 8, on or before May 1st, 2015, we have had legal look at this, and from what we can research, there was nobody in Tennessee who gave out permits for short-term rentals before this point except Nashville. That's how this brings this only to right here. So what we're doing, and Mr. Chair, if y'all would like, I can just go section by section of this bill. I can take questions on this bill. I'm just kind of setting up why I'm doing this. What would the committee like now?
Chairman Faison, just give us a good explanation of your bill. Hit the high points, if you would.
Okay.
I'm sure we will have questions.
So sections 1 through 4 are cleanup from the bill that Speaker Sexton passed. It cleans up the definition of transferred or for grandfather permits to align it with the original intent of the 2018 bill. It creates standards for violations. I think it's interesting that the previous speaker said if they get 3 complaints, but that could be 3 complaints over a 5 to 10 year period. So we looked at this same thing with your driver's license. If you get 3 tickets in a year, obviously you've got an issue. We would say the same thing for that. If you get 3 complaints in a year, you've got an issue, and Nashville should have the right to be able to say, hey, something's going on here. Create standards for violations. The current language reads through more. So section 5 through 8 will apply only to Metro Nashville by using the date in which the Metro Nashville establishment of short-term rental permit and regulation process are also issued the short-term first permit in the city. The amendment protects property owners from being deprived of their ability to short-term rent their primary residence by including the definition of owner-occupied property, which is a property owner's principal residence. Homeowners' private property rights are protected by Metro Nashville banning the use of a primary residence as a short-term rental. Adds the ability for owner-occupied permit holders to sue if the city prohibits any violation of the law. Now, I heard that was a sticking point, and I just wanted to bring this around, and people are like, well, you're setting it up that they can sue for punitive damages. Well, when a person doesn't obey the law, such as me and you, we get a ticket or we get taken to court. That's just what happens. There has to be some type of teeth when you tell government you're going to behave like this and then government doesn't behave like this, and it's egregious to the people. There's got to be teeth. So we're setting this in to make sure that city council and the metro government follows exactly the letter of the law, which we want. We've seen historically how we have people who are supposedly to enforce the law here in Nashville, and they go on before anything's happened preemptively say, well, I'm not going to enforce that law. There is a track record of this community thumbing their nose at the General Assembly. So I feel it's incumbent on us, when you're going to behave like that with your chief person to enforce the law, and they're going to just preemptively say, I won't pass that law if they pass it, I think it's indicative of us to say, hey, you're going to follow laws that we pass. Adds the ability for permit holders to receive court costs and attorney fees if they prevail in court. The amendment would require them to send renewal notices. This other thing, to let their permits go. if you're a permit holder for an Airbnb and never let the owners know that your permit's up. So this requires that they're going to have a 90 days prior to the permit expiration and require them to issue permit within at least 30 days after receiving the renewal application. Since Nashville stopped sending out permit renewals reminders this year, hundreds of otherwise grandfathered in properties did not renew their permits in time, and the city refused to reissue their permits, and that would also stop this. So, Mr. Chair, I'll take questions.
Thank you, Chairman Faison, for that explanation of your bill. We've got a list growing here, so Chair Lady Hazelwood, you are recognized.
Thank you, Mr. Chairman, and I suppose this is a comment as much as a question, but I've been advised this afternoon that even though the date that is in the legislation that the chairman's brought would supposedly eliminate most cities in the state, it actually, one of my cities had an ordinance on the books much earlier that would impact it. And there's just a great deal of concern. I have 5 cities in my district, from small to large, and there's just a great deal of concern about what this could mean, the punitive damage issue, and some other things that we have had a little discussion about here today. While I appreciate that we don't want government overreach, I am also concerned that we would tie the hands of local government, because we've all known about bad actors and things that can happen that none of us would be appreciative of if those things were occurring next door to us. So, Chairman, I love you, and I know that you love me, but I won't be supporting your bill. Thank you.
Chairman Faison, you have anything?
Thank you. I feel like I just got told, bless my heart.
Yeah.
I would just remind the Chair of Finance that, got to be careful of that, don't we all? That the understanding any permits before May 1st, 2015, that does preclude, understand the apprehension. Secondly, I would say that the punitive damages happens to us as citizens when we don't get it right. I think it's a just thing for government to be held kind of at the same standards that we are.
Chair Lady Hazelwood.
And that may or may not be the thoughts and will of the body as a whole, but that is a huge step in a very different direction that we've ever taken before. And I just think if we're going to go down that route, it certainly is worthy of a lot more conversation, a lot more investigation. And again, that's just a serious drawback and a big red flag for me. Thank you.
Chairman Faison. Chairman Holsclaw, you recognize.
Thank you, Chairman. And basically, what we're talking about here is individually owned property. And it's a structure, we're talking about a structure that's not attached to the original property. Is that correct?
Chairman Faison.
That is my understanding.
And that's the only difference that we're talking about in this bill. All right, thank you, sir.
Representative Thompson, you recognize.
Thank you, Mr. Chairman. The whole idea of rights in this country, of us having rights, is that we should have these rights as long as they don't impede on the rights of others. And I just feel that saying we cannot regulate Airbnbs in a reasonable manner impedes on the rights of those neighbors who like us all of us in the city, we have to live sort of close together. We don't have acres of land for the most part, and we need to have for the most part, like our quiet homes and quiet neighborhoods, and I feel that it's going to impede on others if we do that. You do have you change this to, I think it's 3 complaints within a year. That's a full year somebody having to put up with a problem without being able to have any solution to that problem. And that means that that family who lives in that quiet house next to the party place, place where they have the bachelorette parties or whatever, would have to suffer for a full year before they have any relief. So for that reason, I can't support it either. I represent two cities, Memphis, of course, and Germantown, and a large swath of unincorporated Shelby County, and they've all asked me to vote no on this, and I will comply with my constituents.
Chairman Faison, you recognize.
Thank you, and I would just say thank you.
All right. Representative Alexander, you recognized.
Thank you, Chairman. Going back to something my friend and neighbor up there in the far corner, Holsclaw, asked, you said it's a separate, I think he asked you if it was a separate dwelling, so you're not talking about a condo here?
Chairman
You're talking
Faison.
about an individual house?
Thank you, Representative Alexander. This bill is for the people who live in their house. You have to be owner-occupied house. Now, if it was a condo, you've got HOAs at a condo that would preclude anything. This bill has nothing to do with HOAs and condos. This has to do with your single-family dwelling.
Representative Alexander.
That you live in, that you occupy, that's your primary residence.
So you wouldn't necessarily be having parties at it if you're living at it unless you're Jeremy Faison.
Chairman Faison.
Thank you. And Representative Alexander, I was going to answer the gentleman from Shelby County. This
I'm
is
sorry.
no, but that I decided just to leave it alone because I felt like people would understand. This is literally a law that has to do with your primary residence. I think that we would understand that my primary residence, you're not going to be acting the fool. So to answer your question, they're not going to have crazy wild bachelorette parties where you live. This is to rent your mother-in-law suite out of your basement out. And if there is, and also if there is, you don't have to wait a year. If there's three complaints within a week, they revoke your permit. You don't have to wait for the year for that to be revoked. You had 3 complaints within a year. As soon as that third one comes in, you're done.
Representative Alexander, got anything?
Chairman, can we go out of session and ask legal something?
Absolutely. Members, we are going out of session. And Jamie Shanks, you are recognized.
Hi, Jamie.
Go ahead and direct your question, Jamie.
How do I know for sure that this is only about Nashville?
Jamie Shanks, Office of Legal Services. So, for clarity purposes, this bill has 8 different sections, or 9 sections in it, the last one being the effective date. There are 3 sections, well, one section is talking about the new language dealing with prohibiting of the owner-occupied residential dwellings. In that part of the language, there is language that says that when it's talking about the local governing body can do this or cannot do that, for the purposes of the section, a local governing body has expressly authorized property for use as a short-term rental unit prior to May 1st, 2015, if they had introduced and passed an ordinance, resolution, regulation, rule, or other requirement specifically governing short-term rental units on final reading on or before May 1st, 2015, regardless if those were ever enforced, and on or before May 1st, 2015, the local governing body had issued a permit or approved an application for this. That language itself does limit the application for that new language to those governing bodies that have done that. I do not have a list accessible to me to know if that is just one local governing body or multiple ones. there are 3 sections in this legislation that refer to that. And then there are 3 that have nothing to do with that new language and look like they are more broad in application, dealing with the citation pieces of this being within a year. Additionally, the last amendment that was added on further limits this to say local governing body means the legislative body of a city, municipality, county, or other political subdivision of the state that has authority to enact zoning ordinances and employs at least 1 full-time or part-time law enforcement officer, which would further limit it. But again, I do not have a list of those who would have fell either under that or a list of those that would have fallen under the ordinance language.
Representative Alexander?
Mr. Shanks, thank you.
Representative, is yours for legal? Okay, Chair Lady Hazelwood, you recognize?
So,
Are you talking to the microphone, please?
my mother told me to look at the person I was talking to, so I apologize. So if a city had an ordinance in place as early as 2009, which one of mine did, that said you could either run a short-term rental by right in a R3 or R4 zone, or that you had applied to the city for a zoning permit, if that were in place, then would this legislation apply to them?
Jamie Shanks, Office of Legal Services. If they had met the qualifications before the May 1st, 2015 deadline, and they had issued permits or approved applications, and they're also a local governing body that employed at least 1 part-time or full-time, it appears that that new language dealing with this would apply to them.
And one other question, on the punitive damages, am I right in thinking that there's nothing in this legislation that would limit those punitive damages to tort limits? So a city or a municipality would actually, could be sued for and charges, fined for, I suppose, charges above the tort limit.
Jamie Shanks, the only language that I'm aware of that's talking about the punitive damages piece is in that Section 8C2 that just simply says a court may award punitive damages to a plaintiff who prevails in a civil action brought pursuant to this new language against the governing body. I don't believe the legislation addresses that point further.
So it could exceed those statutory government torts. Thank you.
Representative Thompson?
Just so we understand it, what is the definition of residence?
That would be in the current statutes right now for residential dwelling. A residential dwelling means a cabin, house, or structure used or designed to be used as an abode or home of a person, family, or household, and includes a single-family dwelling, a portion of a single-family dwelling, or an individual residential dwelling in a multi-dwelling building such as an apartment building, condominium, cooperative, or timeshare.
Members, while we're out of session and we have legal geared up here, does anybody have any other questions? If not, we're going back into session. Chairman Faison, you are recognized on your bill again. Members, do we have any further questions for the sponsor? If not, members, Chairman Vaughn, you're recognized.
Thank you, Mr. Chairman, and I find myself in a quandary on this, but it's, and the reason it is such is the fact that when people make investments and purchases, they have a reasonable expectation of being able to use their property for what they purchased it for, not be subjected to the whims of of land use matters that are pretty fluid, I guess I could say. And I mentioned last time the fact that even when I'm not trying to preclude cities' rights to change their land use regulations, not at all, because situations change and conditions change. But if I'm a private property holder during that time that it was legal, then I should be able to retain the rights for my legal use at the time that I purchased the property. Seems to me that that has not been necessarily secured in some areas. On the other hand, though, I also find distaste in this body having to get involved all the time because of the actions of local governments precluding that. I understand there's a time and place for it, but whenever has there been a more divisive issue that this body faces on? I don't know that there is. And so whenever I think of local governments who have made decisions that they believe that are in the best interest of their community and stick by those decisions, and everybody knows what the rules are, the last thing I want to do is undermine that. And so I'm stuck between a rock and I'm in a little bit of a quandary in the fact that I don't want to negatively impact people who have played fairly and have been trying to do the right thing for their community. Again, I have no patience with people who do not observe private property rights and don't observe non-conforming uses and granting those rights. And so I guess kind of the way I'm going to shake out on this, Chairman Faze, is I'm going to vote yes today, but I'm going to go back and I'm going to research and make sure that there's no harm to the communities in my area that are going to be would be negatively affected by this, who have done the right thing, who have followed the rules that we set in place, who have said that this is the way that you deal with these. Because again, there's a lot of homeowners associations and property owners association that makes this moot in many cases. So I'll tell you this, is I'll be an aye today, but if I find that it does not honor the good works of the communities that I represent who thought they were doing the right thing and allow them to continue to obey, to use the ordinances they've put in place, then I'll be the most vocal no that this committee will have. And so, because there's a lot of complicated moving parts to this thing. And so that's what I'm going to do. I'm going to look at this and I'm going to continue to take it under advisement, and I'm going to put practical application to it. And if my communities can show me, much the way that our crack legal team displayed to Chair Lady Hazelwood, finest finance chairman in the world.
Hear, hear.
Ladies,
only till the budget's done.
but anyway, I hate this back and forth, back and forth, back and forth. I find it distasteful. But again, if somebody has a cause, needs to have a problem fixed due to actions of others, then that's what we signed on for. But I don't want innocent bystanders to be caught in this back and forth. And that's what I'm going to be looking at and researching hard if this bill does, in fact, move forward.
Chairman Fasing.
Thank you, Mr. Chair. And I would just remind the committee and the gentleman from Collierville that it's never good when we trump local government. But we've done that recently as Monday night, because the local government in your area wasn't doing right by the people, and it was settled for them, and the city council was one way. And there's times that we have to say, you know what, this isn't fair, what's happening to the people. So I sympathize with you, Mr. Chair, that we need to be careful when we do that, but there are times that we have to step in. That's the only thing I'm saying.
Members, before we vote on this, I'm told by legal that we need to do a little housekeeping. These three amendments are going to roll into one amendment, and without objection, they are all rolled into one amendment if it moves forward. Members, do we have any other questions for the sponsor of the bill? Seeing none, we are voting to send House Bill 645 into full commerce. All in favor say aye. Aye. All opposed say no.
No.
The ayes have it. Sir, your bill is on its way to full commerce.
We had to do what we had to do. It's not that we don't.
I was already going to buy Hicks a set of hearing aids. I'm going to get one for.
Members, we are not adjourned yet. Stand by for just a minute. Members, this was our final calendar today, so real quick before we adjourn for the final time, I want to thank the members of this committee. It has been an honor to serve as your chairman this year. Chairman Vaughn, it's been a lot of fun. I've enjoyed it. I want to thank our Sergeant at Arms, Mr. Tommy Woodard, our clerk, Mr. Jack Arrington, our attorneys, Jamie Shanks and Lovin Middleton Dunn, our research analyst, Ben Voitas, and my legislative assistant, Ms. Sarah Noel. And members, without objection, this meeting is closed, subject to the call of the chair, and we are adjourned.